Hello everybody. So today we're going to talk about an interesting topic, and one that specifically has a lot of impact, I believe, in Oklahoma, and that is religion in schools. And I say that because it's no surprise that Oklahoma is a pretty Republican state, and at this point uh, the Republican aspect is a very religious aspect. And so we're going to look at religion in schools and talk about what we can do, how we can do it, and all that kind of fun stuff in regard to religion. So in order to set a foundation for what we're going to talk about, we have to look and see just what the Constitution says. And the Constitution in the First Amendment from 1791 clearly states that Congress shall make no law respecting, one, the establishment of religion, and two, or prohibiting the free exercise thereof. So these are the two parts in the First Amendment that deal with religion and that we're going to look at. And most of our things today will go back to these clauses here. Now, we have actually two clauses that we'll refer to. So item number one, the establishment of religion, is the Establishment Clause. And item number two, the prohibiting the free exercise thereof, is the Free Exercise Clause. And so in talking about the Free Exercise Clause, well, let's talk about the establishment of a religion. And the Establishment Clause deals with any time the government is set out and assumes that it's going to establish or support a religion through its efforts. And really what we see here is the government establishing a religion when a school supports a religious organization. Okay, and by that support, we're establishing that as the religion. I mean as schools. And in recent years, as we'll see toward the end of the presentation, this has started to change a little bit. And we will discuss school vouchers and things like that toward the end, and how the court has interpreted this recently as not violating the Establishment Clause. And so we'll get into that. But talking about the free exercise thereof, a couple of things here. A person has their free exercise rights violated when they are compelled to perform an act against their belief system, or they forego a benefit bestowed by the government as a result of their belief system. And you can easily see where these things are going to come into play as we go into the presentation. Performing acts against their system or foregoing benefits bestowed by the government. We'll get some prime examples of that. An important thing here is that individual beliefs, the Free Exercise Clause has been interpreted that individual beliefs are an absolute right. You and I have the absolute right to believe whatever it is that we desire to believe. The courts have interpreted also that individual conduct is not an absolute right. In other words, while I may have an absolute right to my religious views, it does not mean that I'm going to have that exact religious right to practice them as I see fit in every setting. Basically, that's the conduct part of it. And we'll see that in the discussion. Religious beliefs must be accommodated. Religious conduct can be restrained for the good of all. And so these are some important terms to keep in mind as we go through here, the difference between the belief and the conduct as we're talking about the free exercise clause and violating the free exercise clause. So before we get into the court cases, it's important to note here that most of the Supreme Court cases we're going to look at dealing with religion in school really deal with the Establishment Clause. Few involve that free exercise clause, getting into the belief versus conduct, and most of them deal with the Establishment Clause. And this is going to come into play, as we'll see in general, if we had to give an umbrella for this whole thing. Whenever a school supports a religious endeavor, then that's an Establishment Clause question, okay? Because the school is a function of the government, and therefore the government is supporting that endeavor. And so that's why most of what we're going to see deals with this Establishment Clause. Now, it's interesting to note that while initially schools were established early on, and the earliest schools go back to colonial America up in New England, and those schools were established for the purpose of learning to read and write scripture. That changed, though, and that started changing before the Constitution. It changed after the Constitution, and by the time we get to the 1830s, when Horace Mann is advocating free public education for all, he is saying that at that time that we have to have a free public education that involves no mixture of religion and schools. And so he was advocating, 280 years ago, this idea that, or 180 years ago, that we had to have schools separate and schools could not be used as establishing religion. And keep in mind also that in the 1830s, the Supreme Court really had not gotten into the practice of interpreting laws as to whether or not they were constitutional. They did this early on, and then we see this long, in about 1802, 1803. I can't remember the exact year. They established judicial review, but they really didn't practice it again until after 1830s. Okay, so they went this long period, and it really was not practiced in great extent until the 20th century. That the courts are going to start stepping in and judicial review and start determining whether or not laws are constitutional. And so, with that said, so let's move forward then. So our first big test is going to come in the case of Lemon versus Kurtzman. And this is going to give us what we will refer to from now on as the Lemon test. And this is going to establish whether or not the school is in acting in its role as a government entity, is trying to establish a religion. And there are three parts to the Lemon test. The first part says that legislation or government action has no secular purpose. The legislation or government action must not advance or inhibit religion. And the legislation or government action must not involve excessive entanglement between the states. And so these are the three tests put on any act by the government. That should say religious purposes on that first one. The idea is that all legislation and government action is secular in nature. So that should say no religious purpose or be secular in nature. So that's a mistype there. That should not have a no in there. So anyway, so these are the tests. So government action should have no religious purpose. be secular in nature, must not advance or inhibit religion, and must not involve excessive entanglement between the church and state. And so if a law passes these three things, or as we'll see, could be two later on, but if the law passes these things as a result of a lemon test, then it will be considered constitutional. So let's talk about some various things then. The first thing we want to talk about is release time for students. Release time for students, we're talking here, is it legal to release students? Initially, they started off by saying, is it legal to release students? And if a minister or a rabbi or anybody wants to come in and visit with the students during the school day, is it legal to release them in order to do that? And then we're going to change that to say, well, if they don't want to come in but the students want to go to them, is it legal to release them? And so let's see how the courts interpreted the release time for students. One of the earliest, this is probably the earliest case that we'll see here dealing with religion in schools, is from the late 40s, McCollum versus Board of Education. In this case, court struck down the idea that students were receiving their religious training by the clergy in the public schools. So the clergy were coming to the schools and working with children, and the court struck that down. The students, though, were allowed to choose to attend religious classes if they wished to do so. This was the contention put forth by the school board, that the children could attend or not attend, and the Supreme Court said no, that was not the case. And the reason that this was struck down is basically they said the place that the public school holds in society is so important that the weight the school puts on a program is going to compel students to participate in that program, and that basically for those students who did choose to participate, their days stopped at that point. Okay, so even though the Board of Education said students were allowed to choose to attend these religious classes if they wished, the Supreme Court still said no. Right after that, in order to get around that, we have allowed release time for students to receive in religious instruction from clergy off campus. And in Zurich versus Clausen, 1952, we're going to see this case a lot in some questions later on. The idea that they allowed, the students were allowed to attend these religious services off the school grounds. The religious members could not enter the school. This became known as the Zurich model, and the courts said, yes, this is a legal thing to do. Okay, and so we see our first cases then starting to put some limits and define where we are as far as religion in schools in the late 40s and early 50s, and those dealt with release time. So the next area then that we can go to is prayer and Bible reading. And as I go through these things, you may say to yourself, well, I know that this happens. This happened when I was in school. And that's me telling you, things happened when I was in school. Just because it happens doesn't mean the court has ruled against it. Okay, so what about prayer and Bible reading? 1962, here was the prayer put forth by the New York State Board of Regents. Almighty God, we acknowledge our dependence upon Thee, and we beg Thy blessings upon us. Our parents, teachers, and our country should read teachers. 1962, that was what New York State Board of Regents said would be recited every day in the public schools in New York. Engel versus Vitale. Supreme Court ruled, very important case. This is one of the big ones you need to remember, Engel versus Vitale. Supreme Court ruled the state-sponsored prayers violate the Establishment Clause. Okay, so no longer can we have state-sponsored prayers in school. The following year, 1963, in Pennsylvania and Maryland, schools plan to conduct prayer and Bible readings at the beginning of the day. If the students wish not to participate, they may be excused. Again, the Supreme Court ruled this is a violation of the First Amendment in the case of two cases, School District of Abington Township versus Shemp and Murray versus Curley. So having the prayer meetings and Bible readings at the beginning of the day were unconstitutional in 1963. Let me tell you, I was not even a twinkle in my parents' eyes in 1963, but I can remember starting my elementary school classes with prayer and Bible reading, and that would have been in the 70s. So here's a quote from the case of Shemp. It certainly may be said that the Bible is worthy of study for its literary and historic qualities. Nothing we have said here indicates that such study of the Bible or religion, when presented objectively as part of a secular program of education, may not be consistent with the First Amendment. And this is an important slide to remember because in looking at some stuff here, the majority of Americans don't think that you can teach the Bible in school, and this says absolutely the opposite. You can teach the Bible in school. The question comes down, though, when you're teaching it for a literary purpose versus teaching it for proselytizing. And as a literary device in 1963, 51 years ago, the Supreme Court said absolutely you can use it as a literary device in school. So you can teach religion in school as part of the educational process. A more recent case, dealing with prayer and Bible reading, Santa Fe Independent School District versus Doe in 2000. We will come back to this case quite a bit, so this is another biggie to remember. Nothing prohibits any school student from voluntarily praying at any time before or after the school day, but the religious liberty protected by the Constitution is abridged when state affirmatively sponsors the particular religious practice or prayer. And so this is an important thing to keep in mind here, because what we're going to see in just a second is this is going to bring in other areas of concern, such as extracurricular activities. Okay, so dealing with prayer and Bible reading in school, Santa Fe said absolutely students can voluntarily pray at any time they wish during school. It's done on their own. They're doing it on their own. Okay, the state is not going to get involved. It's when the state gets involved that it becomes an establishment issue. Okay. Another big case to remember, and we'll have a few slides on this, is Wallace versus Jaffrey. This is 1985. Here's a little bit out of order. I need to fix that. 1985, Wallace versus Jaffrey. Let me fix that. Okay, sorry about that. Now we're back. Wallace versus Jaffrey, 1985. The Alabama statute authorizing 1 minute of silence in public schools for mediation or voluntary prayer violated the Establishment Clause. Now, we seem to have something very similar in Oklahoma. So why did this violate the Establishment Clause? Well, it's very simple. The people who passed this law said they were passing it to get prayer in public schools, and the legislature or the Supreme Court came down on Alabama and said, no, this law is unconstitutional, simply because it was motivated by the idea of prayer, putting prayer in public schools. And so what came out of this was the idea of a moment of silence. And that is what we have in Oklahoma, is everybody, I believe, by law, recites the moment of silence statement for reflection, prayer, meditation, personal prayer, whatever the law says. But and obviously Oklahoma was done in the same vein as the Alabama law, but I think that because we have that moment of silence statement in there, we get past that. As I said, the Santa Fe versus Doe 2000, the court said nothing prohibits any public school students from voluntarily praying at any time before or after the school day. So what about graduation then? I said earlier we're going to see how this comes in. And you'll notice that as we get into these later cases, the Lemon test kind of defines religion back in the early 60s and how religion is going to be addressed in schools. And that Lemon test, those 3 parts to the Lemon test, are going to be in place until we start getting into the 90s. And this is going to change. We have a unique makeup on the Supreme Court at this time, I will say. At one point, there were 8 justices on there who were appointed by conservative presidents and 1 who was appointed by a liberal president. And so for a short time, Justice Ruth Bader Ginsburg was the only democratically appointed president on the Supreme Court. And so it's not a surprise to me that we see a lot of these decisions coming down that start pecking away at this Lemon test from 1962, which, by the way, saw more of the opposite. It was ruled by liberals, and conservatives saw themselves as a minority on the court. So what about graduations then? 1992, benedictions and invocations by clergy at public school graduation ceremonies violate the Establishment Clause. So the question then is why? Why did the benediction by a clergy violate the Establishment Clause? What's the connection there? And the court ruled very simply. The connection was this was done by the principal. The invocation and benediction to be given were decided upon by the principal. The principal chose who would give it and chose what would be spoken at the ceremony. Therefore, the courts ruled this is state-sponsored activity. Okay, so what if the students lead the prayer? Sounds like a legitimate response. What if the students lead the prayer? In Guerin versus Loudoun County School Board in Virginia, this is did not make it to the Supreme Court. But the lower courts, and it did not get to the Supreme Court because the Supreme Court did not see a reason to overturn lower courts. 1993 student-initiated, student-written, and student-delivered prayers were considered unconstitutional at these football games, pre-game ceremonies, and so forth. So what about other school activities? Well, this is when we go back to Santa Fe Independent School District versus Doe. Student-initiated led prayer is unconstitutional for pregame. Why is this the case? Okay, so if the student leads themselves to go up and lead a prayer at the game, why would that be unconstitutional? And the courts have ruled that students are elected. In this case, students were elected by the student body by an election process instituted by school officials. So the whole thing goes back to the fact that this was done through the school auspices. The Constitution demands that schools not force on students the difficult choice between attending these games and avoiding personally offensive religious rituals. Thus, nothing in the Constitution as interpreted by this court prohibits any public school student from voluntarily praying at any time before, during, or after the school day, but the religious liberty protected by the Constitution is abridged when the state affirmatively sponsors the particular religious practice, prayer. And so, again, you can see here that all this falls under the Establishment Clause, and that what is happening here is the court is saying that as an institution of the state, the schools cannot sponsor these activities or be involved in them in any way, and that even to an extent, students who are representing the school, who represents the state, cannot lead these activities. What about prayer at school board meetings? Okay, I was in a school board meeting last year that opened with a prayer, not in Oklahoma, it's in a different state, but it opened with a prayer. Coles versus Cleveland Board of Education, 6th Circuit District, 1999, said, no, you can't do it. Okay. Now, again, just because they say you can't do it, people still do it. So until somebody challenges that, it's going to happen. What about other school clubs or other activities? Okay. What about student-led Bible clubs? Can we do that? Can we have Bible clubs in school? And the answer is this involves what we call the Equal Access Act. And so this is an important thing to understand as administrators. And this is where you as an administrator really will deal with this. So basically what it's saying is public schools, says secondary schools, public schools, quite often allow non-curricular groups to meet. And thus, by allowing these non-curricular groups to meet, what the school has done is it has gone from a closed forum to a limited open forum. And we talked about the open forum, limited open forum, and closed forum earlier in the semester. And so by going into a limited opening forum, the school loses a little bit of the freedom to choose what happens. But by allowing these non-curricular groups, and we're going to define what a non-curricular group is in a minute, but by allowing these non-curricular groups to meet, the school has made itself into a limited open forum when student groups are allowed to meet for non-curricular purposes. These could include anything such as a chess club. I think every school I've worked in had a chess club where you had a small group of people get together and play chess against each other, which is a great thing. You can go, there are actually tournaments, I think, for that. But that in itself, as we'll see in a second, can pose issues, potential issues, because allowing that chess club has put the school into the status of limited open forum. Now, I'm not saying don't allow chess clubs, okay? But let's follow the logic of how this happens. The Equal Rights Act states that if a school allows one group and created the limited open forum, the school cannot deny access or fair opportunity to any student-initiated non-curriculum related group on the basis of religious, political, or philosophical content of their speech. So in other words, once you allow that first non-curricular group, and again, in just a second, we'll see what we mean by non-curricular, but once you allow that first one access to the school, you cannot deny any non-curricular group after that. Okay, so just keep that in mind. The concept of no denial to groups was decided in the Mergens case, 1990. So the Equal Access Act, 1984, the no denial groups came down in the Mergens decisions, the Board of Education, Westside Community School versus Mergens, 1990. And in that, the Supreme Court ruled the Equal Access Act is constitutional number one. And number two, that the school violated students' rights under the Equal Access Act by not allowing students to meet after school. And here's a little bit more interpretation of what non-curricular means. And Justice O'Connor, in the 1990 Mergen ruling, said that curriculum-related groups have these three things in common. Subject matter has to be taught, number one. Number two, participation results in an academic credit. And number three, subject matter concerns body of courses as a whole. So you can see then how the chess club does not fit into this. Okay, band, after school band club, fits into this, definitely fits into this. So band is not a non-curriculum related activity. And it quite often meets before school and after school, especially during football season. Subject matter is taught, participation earns credit, and it concerns the body of courses as a whole. So you can see there then what we mean when we say non-curriculum activities. And according to Mergens, the Equal Access Act is constitutional, and once that first non-curricular activity or group is allowed, then all others have to be allowed thanks to the Equal Access Act. And by not doing this, it is a violation of the First Amendment. How about non-instructional activities? Non-instructional activities must be voluntary on the part of the students. Have no employees or agents of the school present at religious meetings except in non-participatory custodial capacity. In other words, we're talking about these non-instructional activities like chess club, these things that create this limited open forum. What are the requirements of these for the school to be involved? And this is what they are. They must be voluntary on the part of the students. No employee or agents of the school present at the religious meeting except as non-participatory or custodial capacity. In other words, they cannot, by law, lead the student religious Bible study because they are an agent of the school. Have no sponsorship by the school, government, or its agents or employees. You know, this raises a question. I don't know. This is just a question. I thought I'd been reading some of this stuff. You know, so if we have a Christian organization or school and we pay somebody a stipend, is that stipend legal? Because this says no sponsorship, but yet we're paying a stipend. So we acknowledge their sponsorship of FCA. So I'm sure there's somebody's come across that. I've never heard how that gets around that. Must not materially or substantially interfere with the orderly conduct of the educational activities of the school. And finally, non-instructional activity. Non-school persons may not direct, conduct, control, or regularly attend activities of student groups. So if it's a student organization, then you can see clearly that the text says that the school is simply going to sponsor it in a non-participatory way, simply to say they're there, they're overseeing it, they're not participating in it, and these students can use facilities and so forth. Speaking of that, what about the use of facilities? So considering that non-curricular groups create a limited open forum, what about other groups wanting to use the facilities? Okay. This is where the Supreme Court came up with a viewpoint neutral idea. Viewpoint neutral. If a district allows other groups to use the building, they create a limited public forum. And this is going to be from the Lamb's Chapel versus Center Mauritius Union Free School District. So this is the Lamb's Chapel case, 1993. You can see all these cases in the early 90s. So viewpoint neutral, then the first thing, if a district allows other groups to use the building, they create the limited public forum. then religious organizations are to be treated the same as other groups. If the school allows a chess club access, it must allow any church access. And as an offshoot of this, and I think the text brings this out clear, as an offshoot to this, an unintended consequence of viewpoint neutral is that schools also have to allow any other organizations to meet, such as the Gay Straight Alliance, which is specifically mentioned in the textbook as wanting access. So that's the viewpoint neutral thing. A couple of more things. Schools have to treat religious groups like other groups. If they do not, then this violates the free speech clause of the First Amendment. Okay, and this comes out of the Good News versus Milford Central School. So, limited open forum. Lamb's Chapel says that once an organization is allowed to participate, then the limited open forum is established, and all organizations have a right to be there in that building participating. 1993 Lamb's Chapel. That same viewpoint neutral mentality said that religious groups have to be treated as any other group. Okay, just clarified Lamb's Chapel even more, refined it even more. And this is Good News Club versus Milford. Okay, so moving on, what about, and this is an Oklahoma issue as well, what about the Ten Commandments? Well, assuming that they're all spelled correctly, maybe that is something that is important. And I say that simply because if you know what's happened at the state capitol, you'll get a kick out of that. So, can we post the Ten Commandments in the school? And the Supreme Court in Stone versus Graham, this actually goes quite a ways back. As you can see, 1980, Stone versus Graham, Supreme Court said, no, you cannot post the Ten Commandments in the school. It violates the Establishment Clause. And I was in a school district just this semester that was telling us about a year or two ago, they had wanted to post the Ten Commandments in the school. Everybody in the district was in favor of it. Apparently, everybody except at least one person who questioned it. And I spoke to the superintendent. The superintendent said that they went and visited numerous lawyers and board members. I talked to board members too. And we got off on a side note about this. And they said every lawyer told them, do what you can. If you need, you're going to lose. There's no way to win this. And so they did not post Ten Commandments at their school. So, but that goes back to a 1980 court decision 30 plus years ago. So they should have known they were going to lose that case. And they did. That's why they didn't spend any money on it. So then how do we go from separation of church and state, and this is the last big topic that we'll cover, how do we get from separation of church and state and all these things about the school being an entity of the federal government and the school operating on behalf of the federal government or the state government, I should say. And how do we get from there to state or to government money being used to sponsor religion? Is that in itself not an establishment clause? And this is where we really see the courts making the switch when it comes to vouchers and tax dollars and parochial schools. So in 1986, we see our first case dealing with this. And this is Witters versus Washington Department of Services for the Blind. This case involved a blind person who wanted rehab assistance from the federal government to study to become a pastor, a missionary, or a youth director. And so the question was, do we give federal money to support religion? Or is this federal money supporting a religion? And the courts ruled, no, it is not. Okay, they said if there is a person who is an intermediary in this transaction, then that person has a right to choose what they want to do with that money. And so Witters, um, I guess Witters was the blind gentleman in the case, had the right to do whatever he wished to do with the money. And the fact that he chose to go into religious business had no effect on whether or not he deserved the money. And that's the way the court ruled. Okay. So then the Establishment Clause has not been violated. So if the aid flows from the government to the individual, and then from the individual to whatever agency or however that individual desires, the Establishment Clause has not been violated. So in other words, the government cannot give it directly to the missionary, but they can give it to the individual who will give it to the training or whatever, non-missionary. That was 1986. A few years later, 1983, we get to Sorbitz versus Catalina Foothills. Catalina Foothills, very wealthy district just north of Tucson. There was a student who was receiving sign language in the Catalina Foothills School District. She had an interpreter with her and went to parochial school in the same area, North Tucson, and wanted the interpreter to go with her. Of course, the interpreter would be paid by the state. And so the question is, does this violate the Establishment Clause? And the courts ruled, no, it does not. This is a mutual benefit for a class of citizens. The idea of the free public education, okay, and that the school district must provide that education. And you can see here, but I'm going to go back to the Lemon test, but the third part of the Lemon test said that there should be no entanglement between church and state. And you can see here in the early 90s, this is what I mentioned earlier, in the early 90s we're starting to see that third part of the test become blurred. Because this case, Catalina Foothills School District was providing a free public education, and the child's parents chose to take her to parochial school. And so the question was, can they send that money with the child? And the Supreme Court said, yes, they can. And so we start seeing that third leg of the Lemon test changing just a little bit. 1997, a couple of more cases here. 1997, Augustini versus Felton, New York Board of Education teachers can provide education services to Title I parochial schools. Public school teachers could work in classrooms leased from religious schools, and schools could fund community educational programs sponsored by religious personnel in religious schools. And so you see here that idea of the entanglement between church and state is really starting to get blurred here. And one more case, I believe, big one here is Mitchell versus Helms in 2000. This involved Elementary and Secondary Education Act, or what we now know, of course, is no child left behind. Money is going to private schools through lending materials to these entities. Okay. In other words, if I'm a superintendent in a public school and I have a private school in my district, can I lend them materials that I purchased through my Title II monies? Here, this is Title II monies. And if I do that, can that be seen as state-sponsored religion? Okay. So that's what we mean when we say if aid first passes through private citizens who are free to direct aid elsewhere, the government has not provided any support of the religion. Chapter 2A is allocated on the basis of neutral secular criteria, supplementary to, it does not supplant non-federal funds. Chapter 2 funds did not reach the coffers of the religious school, and this process is called divertibility. Important term to remember. So again, this money is solely doled out on the non-religious or on secular criteria, okay, and it is supplementary to non-federal funds. In other words, it's supplementary to the state funding the schools are receiving. That's what that statement up there means. And therefore, the courts ruled that if schools purchase material using these Chapter 2 or Title 2 funds, they can then lend them out. And that in itself we call divertibility, and that is not breaking the Establishment Clause. Okay. Another case, 2002, this is the big one that we really see, not just in Arizona, even though this talks about Ohio, not just in Arizona, and I bring up Arizona because it is the, I think per capita, it has the largest number of voucher program type schools receiving vouchers. But also in Oklahoma, we see it becoming popular. Oklahoma is becoming popular in lots of states around the country. And this is the idea of vouchers. Permit public funds to flow directly to parochial schools. And I guess I probably shouldn't say directly to, because it goes back to that idea that we said in Witters. If the aid flows from the government to the individual who then gives it to a religious entity, is not a violation of the Establishment Clause. And maybe that's the same mentality if we were to read more on Zellman. That's what we would find. But the idea of vouchers is simple. It's the tax money that a person would generate in the school is given to that person, and they can use that money then to pay tuition at a private school. And so this finally makes it to the Supreme Court in 2002, and the Supreme Court upheld this case and said this is not a violation of the Establishment Clause, that we have tax dollars going to private schools. More interpretation of the case, it was assistance to individuals. It wasn't given to the schools, it's to individuals. And these individuals practice genuine, independent, private choice. They spend it on education. Even if it is a church-related school, they still spend it on education. And therefore, because they can do that, it is neutral in its respect to religion. Interesting point your book brought up, though, is that in 1999-2000, 96% of the vouchers went to parochial schools. So a couple of other cases that are important here involve Everson versus Board of Education, 1947. And this brings up what we call child benefit theory. And this is an important idea because what they look at is the best benefit for the student here. In this case, actually involved transportation and transporting students to parochial schools on public school buses. And the courts ruled basically the idea that this benefits the child the most, and therefore is not in violation of the Establishment Clause. It benefits everybody equally. And more than half the states now have laws in the books that say this practice can be done using public school buses to transport children to private schools. The last case on here is Mueller versus Allen. This is a 1983 case, and in this, the question of tax credits came up. Tax credits were given for um, uh, given to parents whose children are in public schools. And so the question then comes, do children who are in attending private schools also receive the tax credits? And in Mueller versus Allen, 1983, Supreme Court said yes, tax credits were constitutional for parents whose children attend parochial schools. And that is kind of a summary then of religion in schools. So I gave you a lot of information there. We looked at a lot of scenarios, and I'm going to give you a couple of videos after this before you see questions. But in the videos, what I want you to look at in the videos are a couple of things. The videos come from two sources, first of all. So I want you to look at the sources of the videos, and I want you to see how they treat religion in school, and kind of what your overall thoughts based on what we have talked about here with the establishment and the free exercise clauses of the First Amendment in regard to religion. So take a look at those. I think they're rather interesting. The first one, you'll see the Equal Access Act come into play. They don't specifically say that, but that's what's happening there. And then in the second one, it's a little disturbing because the host, I think, is a little bit misinformed on the law in education. So take a look at those videos. I hope you find them as interesting as I did. So with that, good luck on this. Like I said, it's a very interesting topic. I enjoy discussing with you.